This is lecture number 7 of 7. So after you listen to this one, you will be finished with the alimony lectures. Okay, civil contempt will be covered again in another chapter of the Keene book. However, for now, some basics that are covered in the Lupino book, and I have also weaved in some of the Keene stuff. Civil contempt is a tool to coerce the payer of alimony, a tool to coerce compliance with a court order. There is direct civil contempt, which is a refusal that happens in front of the judge, and indirect civil contempt, which is when the refusal happens outside of the judge's presence. Direct civil contempt means that the judge can hold the payer in contempt for willful failure to pay the alimony when the payer has the ability to pay. One frequently sought remedy is incarceration subject to purge, and this remedy orders the payer incarcerated for up to 179 days, but also permits immediate release of the payer upon payment of the amount that the court had specified, and this is called the purge. If the court finds the obligor in contempt, it must then make a second finding regarding the amount the obligor has the immediate ability to pay, which may be less than or equal to the overdue support amount. The second specific finding of defiance must be based on evidence. Criminal contempt is a punishment. It's a punishment for not paying. There is no purge available in these cases. Up to 180 days in jail when a criminal contempt takes place. Criminal procedures like arraignment, right to remain silent, guilt beyond reasonable doubt, sufficient evidence has to come into play because of the criminal procedural aspect of criminal contempt. The problem with any kind of contempt, criminal or civil, is that it takes a lot of money. But in the criminal situation, the payee's attorney, the person who's supposed to be getting the support, is the prosecutor. And who pays the prosecutor? The person who didn't get paid the alimony. The end result, if proven, is jail. So the person who is supposed to pay the support goes to jail. It's a no-win situation. Civil contempt procedures. What we do is we file a motion with a statement of what the judgment says about the alimony, and tell the court about the payment schedule, what payments received and what are not made, and then certify that efforts were made to informally resolve it, have a hearing, find that a payer has the ability to pay if the judge finds that through depositions and evidence, which costs money. And there must be affirmative evidence and an express finding by the judge that the husband has the ability to pay. I said husband. That was gender. That shouldn't have done that. That the payer has the ability to pay. But in the spirit of civil contempt, which is to bring about compliance, the purge is set to avoid going to jail or staying there for a lesser period of time when the money comes up. If there is an ability to pay the attorney fees and they are found in contempt, then they have to pay the attorney fees. If the payer created the circumstances through voluntary unemployment, for example, that could be a situation of contempt. But again, there must be a finding that there is a need and ability to pay. So we're looking at attorney fees from the same same guidelines, legal guidelines of need and ability to pay, as we would look to alimony. So the same scope. And just like, like I said, just like alimony requires. This stuff is hard to figure out, and it really is a no-win situation. The court doesn't often, do this, give attorney fees. It costs a lot of money, and the payee just doesn't often get anything in return. Now, as far as enforcement of orders of divorce orders of like alimony, child support, etc. We'll cover that again in much more detail in another module, separate and all by itself, because it's a lot more than this simple little stuff that we've talked about. But at this point, The book covers it in Lupino, so I wanted to at least address it so you didn't think we were just skipping it altogether.